Welcome to the Hawaii Board of Naturopathic Medicine virtual meeting. Before the meeting is called to order, we will play a short video to explain procedures for this virtual meeting and how members of the public can participate and interact with the board during the meeting.
Welcome to the Professional and Vocational Licensing Virtual Board Meeting.
When the meeting begins momentarily, the chair will take a roll call, explain any specific rules for this particular board, and then move to public comment. The name of the board member will appear on the bottom left-hand corner of your screen. For instance, this is board member Y, and this is board member E. Public testimony will be accepted at the beginning of the meeting and before each agenda item. You can indicate that you are ready to testify by clicking on the Raise Hand button being circled by the mouse on your screen now. At the appropriate time, the board will recognize you to speak and ask you to unmute your mic as shown here. Again, public testimony will be accepted at the beginning of the meeting and before each agenda item. Public attendees will not be able to unmute their microphone until recognized by the board. Public attendees who are recognized to testify will be asked to identify themselves by name and their affiliated organization if applicable. Please mute your microphone when you are finished speaking as a courtesy to others and members of the board. Public attendees will not be able to unmute themselves after the testimony is completed unless recognized again after raising their hand. At some point during the meeting, the board may choose to move into executive session. When the board moves into executive session, the board members' microphones and video feeds will be turned off, and a similar screen as you see now will be displayed. When the board returns from executive session, their microphones will be turned on as well as their video cameras.
Welcome again to the Professional and Vocational Licensing Virtual Board Meeting.
At this time, the chair will call the meeting to order and take a roll call, as well as explain any additional rules that may be specific to this board.
Internet access. To view the meeting and provide live oral testimony, please use the link at the top of the agenda. You will be asked to enter your name. The board requests that you enter your full name, but you may use a pseudonym or other identifier if you wish to remain anonymous. You will also be asked for an email address. You may fill in this field with any entry in an email format, for example, janedoe@gmail.com. Your microphone will be automatically muted. When the chairperson asks for public testimony, you may click the raise hand button found on your Zoom screen to indicate that you wish to testify about the agenda item. The chairperson will individually enable each testifier to unmute their microphone. When recognized by the chairperson, please unmute your microphone before speaking and mute your microphone after you've finished speaking. If you cannot get internet access, you may get audio-only access by calling the phone number listed at the top of the agenda. Upon dialing the number, you will be prompted to enter the meeting ID, which is also listed at the top of the agenda. After entering the meeting ID, you will be asked to either enter your panelist number or wait to be admitted into the meeting. You will not have a panelist number, so please wait until you are admitted. When the chairperson asks for public testimony, you may indicate you want to testify by entering star and then 9 on your phone's keypad. After entering star and then 9, a voice prompt will let you know that the host of the meeting has been notified. When recognized by the chairperson, you may unmute yourself by pressing star and then 6 on your phone. A voice prompt will let you know that you are unmuted. Once you are finished speaking, please enter star and then 6 again to mute yourself. For both internet and phone access, when testifying, you will be asked to identify yourself and the organization, if any, that you represent. Each testifier will be limited to 5 minutes of testimony per agenda item. If connection to the meeting is lost for more than 30 minutes, the meeting will be continued on a specific date and time. This information can be found on the board's website. Instructions to attend the Hawaii State Virtual Board meetings may also be found online, including in the board's website.
Thank you. I will now call the meeting to order, and we will take a roll call to confirm quorum. Members, when I call your name, please respond with present or here and indicate whether you are in the room alone, or if anyone 18 years or older is present, please identify them. Vice Chair Dr. Corinne DeSoto.
Present, and I am alone.
Thank you. Ms. Joy Kimura
Present, and I'm in my workspace alone.
and I, Chairperson Dr. Kristen Coles, am also present and alone. So with quorum established, I call the meeting to order at 2:13 p.m. We will move on to agenda item number 2, which is our executive officer report. And are there any attendees wishing to provide testimony?
Thank you, Chair. This is Johnny. We do not have anyone requesting to provide testimony.
Thank you. Our executive officer, Chris Fernandez, will now provide the EO report.
Thank you, Chair. All right, so we had wished to inform the board that we were going to have a change of assignment, myself moving to another board. However, at this time, we're delaying that. So we're just going to bypass that one for now. B, we received a letter from Dr. Virginia Osborne, who wished to correct the dates of a IV nutrient therapies training in Dallas, Texas. She had explained that she had placed the correct date range of September 5th, September 8th, 2024 on the applicant's certificate. However, the application that the board approved at its meeting had just, the dates were just shifted off. So she just sent in a letter of clarification. We ran it by AG. They were okay with us just making the change and then announcing it here in the meeting. So that person's, everything's cleared up, so we can go ahead and move ahead with licensure on that, or the added privilege. Okay, then the last thing for the EO report was, so as everybody knows, December 31st of odd ending years is the end of the licensing biennium, so everybody's gonna need to renew. Usually around October or November, I send out a memo that provides instructions again, kind of detailed. It started, I think, with the previous executive officer because the CE program had just come online. So we were really trying to help people educate, so we would have less, deficiencies, things like that. Throughout the several renewals we've had, I've seen a sort of increase in, it seems like, people's ability to understand what it is. We still have deficiencies. I guess at this point, I was just gonna say, we are gonna send it out this year. But in the future, I might ask the board if we may omit it because it is an additional task here. So if the board feels like its licensees are well-versed, then we can again, just omit doing that on the renewal years, or you can continue it if you like. But that is it for the EO report.
Great, thank you. So we will move on to agenda item number 3, and that is approval of our meeting minutes. So the board will now review the meeting minutes from its March 14, 2025 publicly noticed meeting. Are there any attendees wishing to provide testimony?
Thank you, Chair. We do not have anyone requesting to provide testimony.
Members, are there any comments or corrections for those meeting minutes? I don't hear any comments.
This is Joy Kimura. No comments or questions regarding the minutes. Thank you.
Thank you. Can I get a motion to approve the meeting minutes for March 14th, 2025?
This is Corinne DeSoto. I motion to approve the minutes for the March 14, 2025 meeting.
This is Joy Kimura. I'll second the motion.
Okay, excellent. So we will approve the meeting minutes for the March 14th, 2025 meeting.
Chair, we'll need just, you can state, are there any objections or abstentions, and that'll complete the vote.
Okay. Are there any objections or abstentions? I, Chair, have no objections. So we will approve the meeting minutes for the March 14th, 2025 meeting. And we can move on to item number 4, which is applications. Is there any attendee wishing to provide testimony?
Thank you, Chair. We do not have anyone requesting to provide testimony.
So the board will now review the list of approved applications to be ratified. We have that list that was sent to us. Members, are there any comments or questions?
I have no comments or questions.
Hearing no comments or questions, I motion to approve the ratification list of the approved applications. Can I get a second?
I second.
So Dr. DeSoto seconds the motion. Any objections or abstentions? Hearing none, the list of approved applications is ratified. Okay. And then do we need to do the approval for the qualifying course on parenteral therapy? Chris?
Yes, Chair. The two courses that are on the agenda, the March 6th to 9th, 2025 in Pomona, California, and the September 4th through 7th, 2025 Denver, Colorado courses. In the board packet, you guys have the application form. As you know, IIV and TP are basically the standard course that is requesting authorization on the regular with us. So there was no noted changes to their program nor their staff, so they did not include any additional documents because the board already has that on retained. So you can go to executive session to discuss, or you can, based on, your brief discussion here, to approve or deny or defer.
Right. Okay. So we have traditionally approved these courses. We are familiar with Dr. Virginia Osborne and her courses. Do members have any comments or questions? Okay. Being that I hear no calls for further discussion, I motion to approve the non-school course agreement for parenteral courses from March 6th to 9th, 2025 in Pomona, California, and September 4th to 7th, 2025 in Denver, Colorado. Who seconds the motion?
This is Joy Kimura. I'll second the motion.
Thank you. Any member wish to abstain or oppose the motion? Hearing none, the list of approved applications is approved. We will move on to item number 5, which is the discussion on testosterone and the naturopathic formulary. The board will now continue reassessing the inclusion of testosterone on the board's naturopathic formulary. The board will also review the formulary generally with regard to its structure as an inclusionary formulary and pursuant to HRS 465-6. Is there any attendee wishing to provide testimony?
Thank you, Chair. We do not have anyone requesting to provide testimony.
Okay. So Chris, I believe we have some updates from you that were in our packet in terms of some discussions you have had, correct?
Yes, Chair. So what I included was the public information, the public information from SB 223 from 2017. I think this was like one of the last times it was went through the legislature, and like this time in 2017, it almost passed. But I included that the bill as it stood at I believe at the end of the session, or at the beginning and then the end, so you could see the difference in the in amendments. I also included the testimony at several different committees, just because we want to see who was saying what, with regard. I know the Osteopathic Association had a lot to say. So I did included that. I also included an email from a DEA rep with regard to the prescriptive authority for mid-level practitioners, which nationally is how naturopathic physicians are identified in the basically within the DEA. So after the meeting in March, going through legislature, I was also there for pharmacy bills, etc., which meant I ran and crossed paths with Deputy Director Radula from the Narcotics Enforcement Division. And so I took the opportunity to reach out and talk with him about the naturopathic, matter that we're discussing right now. And he was gracious enough to be able to speak with me right before a hearing. We both had to testify, so I was very gracious to him to have done that. And what I gathered from him was that I needed to speak with the DEA office, but to confirm their side of things. But within his wheelhouse, he was stating that what is best for them to issue registrations would be to have clear language that actually directs them to do that. Now, like I said, he stated that it is best that we do that. This kind of coincides with what our DAG was discussing last time. So with that, he had suggested I reach out to DEA. So I did so. And part of my questions you'll see in the emails. But it's basically the same question that we had for NED, which is, what does the licensed naturopathic physician need in Hawaii to prescribe controlled substances? We went over like the not my spreadsheet, but we went over something similar that she had that she was reviewing with me verbally. And so we were both kind of going through that the prescriptive authorities for those states is basically in their statute. It states clearly that, like, for example, I think in DC that they can use testosterone, for example. Sorry, I gotta bring up that list so I can clear, but. Yeah, so Washington, DC, for example, is an only testosterone state for prescribing. I noted the title and chapter and section that it's in their statutes. The other thing that she was happy to do for us was to reach out to their council, their federal council. And she had to actually caution me that it might take a while to actually get any response. So I was surprised that about a week later, she actually said that they got back to her. And I think they echoed the same thing, which is basically clear, explicit language about what prescribing authority exists would definitely initiate the DEA to issue a registration number. Without that, though, it kind of goes along the same lines as what Dag Ching was talking about last time. So, yeah, that's kind of like the new information. The other thing I wanted to add in my research that I found with regard to SB 223, and I brought this up with Jordan just before the meeting, was that the bill modifies both chapter 329 and 455. And I think that's something we've always discussed, that both would need to be affected if it was going to be a statutory change. As you'll note in the bill, the definitions section, I wanted to focus on because it creates a new definition specifically for naturopathic physicians, in the same vein that was done for APRNs. I'm guessing the reason they made that definition was because an APRN would be unable to meet the definition of practitioner. But in naturopathic physicians' case, I'm wondering if naturopathic physician was placed under practitioner, if all those would be affected too. Meaning if you wanted to amend something for naturopathic, increase, like say prescriptive authority for controlled substances, it may affect that definition. So it seemed to me like a good idea to keep your own definition so you can modify it alone and not deal with any of the other practitioners that would be within a same definition, if that makes sense. Does that make sense? Because if you're in a definition of practitioner, any changes or modifications to 329 under practitioner would have to be changed, throughout the chapter. But if you're a standalone naturopath, you can just include the new language based on that definition. And you can also increase or decrease the authority, and it would only affect that defined practitioner type, which would be naturopathic physician. I think, to me, in my mind, the bill seemed to be good construction.
Can I ask a clarifying question?
Sure.
Or comment. I think I understand what you're talking about is, keeping a separate definition for naturopathic physicians. There has been talk at times to try and see if we can't get ourselves to be included under the definition of practitioner, just because that way, if we don't have to go through things one at a time in every single statute for every single thing that we're trying to, add to our scope of practice. And what I think I'm hearing you saying right now is that in this particular case, it makes sense for us to maintain a separate naturopathic physician's definition and not try to be included under practitioner, because we would, as a board, would want to modify our formulary in a way that is different than everybody else under the practitioner category.
Yeah. I think that it kind of frees you guys up to handle things without having to deal every time you have to change the chapter with that practitioner deal with things within that practitioner definition. So that term is used throughout the chapter, right? And it refers to all those different types of license types. So if you're going to modify the definition, you're going to have to modify every single one of those sections throughout. The more language you start to affect, I don't know how that affects how they're viewing it at the legislature. It might be, they think, oh my gosh, that's too much. And that's why I was saying that the way they constructed it in 2017 was a good construction in my mind. I don't know other outside of my job, to say it's just anecdotal, but yeah, it was constructed to me like very clearly. And it seems to, when I look at the email from DEA, it seems to meet what they are saying would need to be in place.
Thank you.
So what you are alluding to is that the way forward, according to what you have received from DEA and NED, is that the way forward is to do it like a bill similar to 2017.
Yeah, well, I guess I'm saying that there's no question in the mind of DEA or NED if it's explicitly stated in those statutes whether a registration would be issued or not. So it would be issued if it was explicitly in there. So I think that's what I'm saying. How it's addressed, obviously, it only leads to one option, and that is, yeah, like you said, to draft a bill and introduce and get it passed.
Thank you so much, by the way, for this work, speaking with everybody at DEA. I really appreciate it, and I appreciate their time as well. The email conversation that you had kind of ended with your question of, or I think this is actually the question from Anastasia Martin about what is Hawaii's NED response. It sounds like NED and DEA maybe have different opinions on the matter. And I didn't see, is there included a follow-up about a conversation or a response from NED, or that's still pending?
Well, I don't know if I can't recall from my conversation if she knew I had spoken already to NED.
Oh, okay.
But I do know that in my conversation with her, the federal regulators are not going to step into the state's arena if they can help it. So when I ask, will our NED register to the DEA? They're going to say, well, I don't know. What did they say? So, so I kind of have to take what I can from both parties and kind of see how those fit together with the purpose that you guys have. And, that kind of dovetails well with what, Daxin had brought up at the last meeting. So, I kind of just was positioning things there. Again, like you said, there is a little bit of I think it's because they want to stay within their wheelhouse. They won't answer anything for the state, and the state won't answer anything for the DEA. So I think that's what you're seeing, but I could be wrong. I can definitely ask NED again after speaking with DEA, any additional information.
Well, I was just kind of trying to interpret the response from the email from the DEA, because the language that you included comes directly from our formulary, correct?
Correct.
And they stated that the verbiage in the formulary would be sufficient as long as it explicitly stated that naturopathic physicians can prescribe controlled substances, which kind of brings us back to our conversation that we always keep circulating of, can we just change the language, since, the board has the ability to manage the formulary. Obviously, best practice would be to do it through a statute, but we still haven't ever heard from anybody that we have to do it through a statute and that we can't do it just through the board changing the language in the formulary, correct?
I think from the conversation we had at the last meeting, I don't know if I don't know. Would you say that you're?
I mean, we're skirting on. I don't know if we want to enter into executive session, but I mean, I'll try to answer it generally. But if you have more specific questions that may amount to attorney-client privilege, we can stop and vote on executive session. But I think generally speaking, what was stated, I mean, is that our administrative rules need to be consistent with our law, and the law is, it doesn't provide for this power. So to that extent, it would be inconsistent. The best way forward would be through statutory amendment. I think that's what was discussed.
Right. If I remember, it was basically that they don't fully line up, since the law doesn't say exactly what I'm so sorry. I kind of get confused sometimes between the statute and the law. The statute, it doesn't fully say what the law says, which is that the board has the power, but to manage the formulary, but the statute doesn't state that as well.
Yeah, and I think what's not damning, but what kind of works against an interpretation where the board would have that power is that, I think it was in 2009 where I think they tried to make a change, and it was ultimately that language was taken out to allow the board for this power. So I think the court may interpret that disfavorably, in determining whether or not the board has that power.
This is Joy Kimura. So I have a question. Would it be possible for the board to change the wording to and then after we change the wording so that the naturopathic board can amend the formulary, then can we pass or try to pass a bill to solidify that into law? Because
What do you
it'll already
mean?
be
What
in-
language are you referring to change?
I'm referring to what's in, I guess, the responsibilities of the naturopathic board and what constitutes what a naturopathic physician can use in their formulary. So,
I see.
so because I'm not a naturopathic physician, so please forgive me if I don't have the correct terminology. I was wondering if it's possible for this board to amend the language so that we include testosterone in the formulary, and then because we're the board, we can do that. And then after that, introduce legislation to solidify that into law, because then we can say, well, it's in it's in our formulary, right? So now we're going to solidify that into law. Is that possible?
Well,
Because
I guess I'm
we can
I guess I'm
change
misunderstanding what you mean by amend the language. Are you mean the rules or the laws or?
the rules, and
Oh, the
then
rules. I
because
see.
we can do that as a board, can we then introduce legislation to solidify testosterone as being in the naturopathic um, formulary, that naturopathic physicians can prescribe testosterone, solidify that into law. But because it's in because our board has already amended the definition of what is in our formulary, can we then solidify that into law with legislation? Because we as a board, don't we have that power to do so?
Well,
Just
the
on
only
paper?
definition for formulary is in the statutes, so you couldn't just change it. That would be a statutory change, and I'm in the rules now, and I'm looking at definitions in there, and the only thing that's defined in the rules is board. So there wouldn't be, you could include a definition of formulary in the rules, but what would authorize that in the statute, I'm not sure.
Yeah, I think that would be kind of a little backwards from what needs to be done. You can't change the rules to enable a law change. The law needs to be changed to allow an agency or a board to, because laws, I mean, the rules, are only meant to, express the express and implied powers of a agency or a board. And so we can't rewrite the rules to encourage a change in the law. It's the other way around.
Well, I understand that,
okay,
but I was
it's
just
the
thinking that it's
authorities.
easier to amend the rules than to pass legislation. So I know it's kind of a convoluted way of doing that, but if you look historically, to pass legislation to allow testosterone in a naturopathic physician's formulary, you're going to have incredible opposition from the general medical establishments. So I just thought if there was some way to get some support in a different manner to
Right.
solidify our position and then introduce legislation, it may be a little bit stronger. That's my only way. I was just trying to think out of the box, something, just to help the cause.
Joy, I appreciate so much, you trying to think about it, because I think that's where we continue to keep trying to clarify here is, and I wasn't on the board in 2017, so I don't know how that process went, but, we have tried this a few times already, and there was support, is my understanding at the time, quite a bit of support for the bills when we tried to go through, and then it either didn't pass. Actually, maybe Dr. Coles, if it didn't pass just because it didn't get a
No.
hearing.
They refused. It reached a certain point, and they refused to bring it to the next hearing. So we could not get it to move forward, not because of any reason other than the rep. And I can't remember the details, obviously, in on my head. It's somewhere, but they would not hold the hearing for it.
I think it was judiciary, with the House. I think the Senate passed it through. So I think it was in the House, and I think it was towards the end, which would have been either judiciary or judicial or ways, not ways and means, financial, right? So those are the last two committees they usually go through. And it was right at the end. I did notice that the votes, I don't know if you looked at like the SB 2017 on the legislative website. I don't know if you're familiar with how to do that. I can obviously show you guys how to do that. But you can look at like the vote taking for the committees and even for the floor vote. And as it traveled through, and especially on the House side, you could see that there was a lot of like support with reservations. And I don't know what that was about at that time. Obviously, it's so far now. I was probably there at that hearing, but I could not remember now. It's unfortunate because now we have YouTube videos, we can go check it again, but not for the 2017. I don't really know any specifics about it, but certainly at that time, the Senate had no issue with the bill. It was the House side. So sometimes you might see in legislative session, both houses are opposed, and then you don't even get a hearing, but it was good to see that it went through. Now, I can't remember, I think there was one additional introduction sometime between now and 2017, but I'm not sure it went anywhere. So, yeah, I think that's so much the history since 2017 right now.
Yeah, I know we had Roz Baker, who was a huge proponent for us and for that bill back then. She was instrumental in helping us like get the bill, get it through health. Yeah.
Is there, do you want to call them?
Oh yeah, sorry. We do have a hand up chair for Dr. Michael Trout. So if you're willing to bring him in, we can bring him into the meeting.
Yes, so we have a attendee wishing to provide testimony, so I would like to bring Dr. Michael Traub into the meeting.
Thank you. I'm listening to the discussion here, and it seems to me like there's not clarity on the part of everybody at the meeting about what the statute says regarding the board and its authority to establish our formulary on an annual basis. And to me, that's a very simple, clear statement that says that the board does have this authority. And so I'm not understanding why that's in question. It's section 4556, number 7, where it says annually establish and publish a naturopathic formula that's been approved by the board.
Thank you, Dr. Traub. That's very important information. Thank you. Sure, Kimura. So with the information provided by Dr. Traub, as I was saying earlier, couldn't the board just include testosterone in a formulary, accept that as part of our formulary, and then try to pass legislation to support that? I know it's a little bit it's a unconventional way of doing things, but just throwing that out there.
I can respond if the board wants. And I'll just briefly say it's true that, the board does have statutory authority over the formulary, but Chapter 455 also defines what the formulary, and it doesn't include controlled substances. And this is, again, something that was considered in prior legislation to include it, but it ultimately wasn't. So to write to respond to Ms. Kimura, your suggestion, generally speaking, again, rulemaking has to be consistent with the powers that are granted by our statutes. And we can't use rulemaking to circumvent the legislative process. We shouldn't be making rules that may be considered inconsistent to the powers that are granted. So
I think that's the major issue we've always had, because specifically the definition of naturopathic medicine, for example, is not the AMA standard. So when they classify medications differently than I'm guessing naturopathic physicians. So this is the case I'm thinking is that testosterone as a hormone, which is a hormone, which has a definition in the formulary, right? Or it has a role in the definition of the formulary, right? Hormone. And I think that's what you're alluding to, right? Is that testosterone is a hormone. But the unfortunate fact is that it has been restricted by the federal government as a controlled substance, which now like has this additional weird issue, right? Because on one hand, it seems as if it's a hormone, it can be prescribed by naturopathic physicians, and that's supported by your guys' practice and your education now. So, but as far as the federal law and the state law is concerned, it's to me, it seems like another question. And when I'm looking at the email from the DEA rep, I specifically asked about what you're asking, is the term hormone enough for the board to prescribe this? And what she stated was it would need to be need to be explicit to the drug, basically. So, and that's consistent with the other states and what they included in their statute. So, I can't remember. Arizona has a little bit of difference. But I think that when it comes to the testosterone inclusion in states' formularies, I believe that it's explicit in all of their statutory chapters. So I think that's what she responded based on. And I think that was supported by their counsel.
And when you say explicit, you mean we can't just list testosterone on the formulary as is. We would have to have a separate area that said, and Schedule 3 medications such as testosterone. Is that what you mean by explicit?
Well, I mean, like you would literally say testosterone. So for example, even one of the states, I'm sorry, I can't recall which one, specifies naturally derived testosterone only in their statute. So they can only prescribe naturally derived testosterone. So that's what I mean by explicit. It doesn't just say hormone, because hormone isn't just testosterone. There are other hormones, right? So
Right.
I
I think we understand that, because that's the question is, can we not just add the verbiage testosterone? I think we're all on the understanding that in order to have it on a formulary, it would need to say testosterone. But that is not enough, is what you're saying, to have it listed as testosterone is not to have it listed
well,
as testosterone.
I guess it comes to the fact that I feel like I would need to do more research about how, from the pharmacy side of things, how they handle this, because they all retain a copy of your formulary. And they reference that. So sometimes, once in a while, I'll get a call from a pharmacist asking, can they prescribe this specific medication? That's when I send those questions to you, Chair. What I'm saying is, what would be the case if testosterone was included on the formulary, because that's supported by the board's authorities in Chapter 455? What supports it is that you can modify the formulary, right? You have that authority. Not that you can include testosterone, just that you can modify the formulary. What is to say that what would happen with something included on this formulary that actually cannot be prescribed? And so I think that's the issue to me is, will we start getting an increase of calls from pharmacists asking, can they prescribe this? And my answer what would my answer be? Because I would have to say, obviously, well, they need the NED registration. Do they have that? And so their response would be no, and obviously the medication in the end wouldn't be filled, but why is all of that happening? That's my question. And so it could increase clarity, or decrease clarity, sorry. And I think I'm thinking about those administrative types of issues. And what would happen if some pharmacist accidentally filled it on a naturopath? Obviously, it would be their error. But what would the Board of Pharmacy, I don't know yet, because I've never posed this question there, but what would they have to say about that? So I think there's other concerns, you know. I did ask her also, you know, would they have to have some kind of like business registration or something like that in order to like retain controlled substances on the premises, things like that. Just other additional questions that would be like the case for, because it's not just the authority to prescribe the testosterone, it's also that infrastructure that surrounds managing controlled substances.
So, I mean, just to point out, there are naturopathic doctors who practice in the state of Hawaii who do have DEA numbers from other states that they have licensure in. Now, they cannot prescribe testosterone or other scheduled controlled medications, even though they have a DEA number because it's not in our formulary. But there are naturopaths who have DEA numbers who practice in Hawaii. So just so that everybody is aware that there's a process to get DEA numbers, and doctors can get those because you can have licensure in the state of Washington, which allows you to apply and have DEA numbers and prescribe controlled substances there.
I guess my follow-up question with DEA would be, does that authorization in Washington authorize here? And my guess is
so
no.
A DEA number is national. Now you have to, obviously, when we apply for licensure in the states that we are practicing in, we follow the practice laws in the state we are in, and that is our responsibility as naturopathic physicians to understand the law of the state we are in. But what I'm saying is that your sort of like questions about, oh my gosh, how would someone get a DEA number and this and that, like it's not that difficult because there are doctors who have licensure in Hawaii who have DEA numbers from other states. But they're not going to be prescribing testosterone in the state of Hawaii because they can't. It's not on our formulary. But if testosterone was on our formulary and a practitioner has a DEA license already, that's what is needed to prescribe.
Well, you know, it's like that's an interesting thing is like, I don't think the DEA issues their registration. It's the states that do that based on their own statutes. So I would say that your registration, while it might be national, it's only valid for the states that it's valid for, right? So it wouldn't be valid in Hawaii because we don't have the supported statute statewide. So, and I think that's the thing that keeps going back to why it should be explicit in this chapter and 329, because there would be no question on naturopaths at all because it is in there. And, you know, for the questions about whether or not the whole entire schedule needs to be open to naturopaths, I think that's another separate question. You know, like I see that other states have restrictions on the schedules, right? So I can do Schedule 3, but only testosterone. But, you know, so you can add additional controls to it. So this question that I've seen like in testimony at the legislature about, oh, if you give them prescriptive authority, they're gonna like go all out and do all these things. I'd be like, no, because they obviously weren't reading the bill language. And at this time, we can provide testimony support to emphasize that that's the case if a bill ever were introduced, you know. And so to kind of tamp down that.
I mean, that is what we did in 2017, and I was at the Capitol every week meeting in person with senators, reps, like trying to talk them through. The only thing we are asking for is testosterone XYZ. But the reason there were all those votes with reservation is because, yes, I mean, people don't listen or they don't understand that like what we're asking for is only something so small. It looks like Dr. Michael Traub has his hand up again. Are we able to allow comment again?
Yes.
Can you hear me?
Yes.
Okay. Section 4551 of our statute defines, where is it here? Naturopathic formulary means vitamins, minerals, etc., and those legend drugs consistent with naturopathic medical practice. So testosterone's a legend drug. Controlled substances is not mentioned anywhere in our statute or in our rules. And so I don't think the fact that it's not there means that we can't do it, because controlled substances are in the category of legend drugs. And if the board adds testosterone to the formulary, to me, it's consistent with the authority of the board.
Thank you
And
for that.
just for the record also, the DEA number is issued by the federal government. It's not issued by the state government.
Sorry, you are correct. I mean, it's issued on the basis of the state statute
Right.
in that state. So wherever you're accessing the registration, Hawaii, California, et cetera, it would be based on their statute in that state.
Right.
Yeah, that's what I meant. Sorry. Thank you for the clarification.
Thank you. I have to go now. So thank you for letting me be involved in this discussion.
Thank you, Dr. Trout.
I think just to follow up on what Dr. Treb was saying, you know, his point is, and I think that this is like our sticking point, right? Is that the formulary doesn't specifically state controlled substances, but it doesn't exclude them either. And it does include all hormones. So, you know, if you just go based off of the wording of the definition of naturopathic formulary in statute 455, there's nothing that contradicts that testosterone can't be included.
Yeah, I think it's not a matter of contradiction for me. Really, it's more a matter of what does everyone else say? What is everyone else going to do? Because it's not explicit. You know, like, for example, I will get regular calls, whether it's for naturopathic, psychology, speech pathology, asking about telehealth. And our normal response is to state it's neither permitted or prohibited. It's like that gray area, right? And so I have to say that because there's no guidance from the language. And so it really leaves things in a gray area. And I think what Ching was trying to express last time was that this could open people up to liabilities. So the best way to protect the profession would be to have it explicit only in that framework, not whether it's prescribable by the experience of a naturopath. It's only based on what happens, you know, when that medications are actually dispensed, not by naturopathic physicians, but by everyone else.
And to clarify, does the medical board, does their definition in their statute specifically state controlled substances? Like, are we missing something that every other board includes in their statute? Or do we just have to say it because up till now we haven't had it?
Well, you know, I had thought about that question. And I had looked at their statutes and, you know, I mean, it goes without saying that they're not going to be treated in the same way all other practitioners are going to be treated. And that's unfortunate in a sense like this, when we're trying to address this matter, because it doesn't support any kind of direction. They kind of can prescribe whatever. So I think what I go back to is the national categorization of naturopathic physicians. And that is to categorize them as, I'm sorry, what was the term?
Mid-level.
Mid-level?
Yeah, mid-level practitioner and so I don't even look like to be one-to-one with medical, not only on this subject, by the way, only on this subject, what we're talking about, not generally, because you guys have in your chapter in the it's like the renewal section to stay, it's like 1-for-1 your practice versus there. So there should be no issue there, but
And then to clarify on that then, so if we look at other mid-level practitioners in the state of Hawaii, such as advanced practice nurse practitioners, I know that there are different license types for APRNs. So does their statute specifically state controlled substances versus not controlled substances? Like it's just they prescribe or they don't prescribe, as far as am aware.
Okay. That's an interesting question because maybe if they're not restricting the schedules, then it's not necessary. But if you're gonna restrict to specific types of medications, because you wouldn't want your, all naturopaths to have like access to all controlled substances, for example. I don't know why, but let's say you have to restrict it, then I guess you would need that additional language.
Well, what I think, kind of this is maybe going back to Joy's point, but in a slightly different way of looking about it, is that what we can prescribe is maintained in the formulary that the board updates all the time. And right now, the formulary states not testosterone. But if the formulary states testosterone, then that's already restricting the prescription of all other controlled substances because the formulary doesn't include it, right? So it kind of goes back to this question of, if we look at 455, it does not prohibit controlled substances. And that's what was passed originally, right? When the law went into effect, it just says legend drugs. And then the formulary that we publish is the one that restricts it. And so we should be able to just say that testosterone is allowed. We don't put anything else on there as far as controlled substances. That, implies that we are, as a board, stating that testosterone is okay, and it doesn't end up conflicting with 455. That's my understanding of it. And it's not inconsistent either with other mid-level practitioners if it does, if the controlled substance prescription is not explicitly stated on the nursing board as well. I mean, if we wanted to protect the practice, based on any concern that it's not explicitly stated in the statutes, then I guess we could always go back later and try and add that in just for protection purposes. But it's like, it's not, it doesn't look necessary because of the language and because of what, the other mid-level practitioner boards say.
I think we're kind of bordering on it. If you want to continue the conversation.
Should we go into executive session?
Yeah.
Great. I'd like a motion to enter into executive session.
Sorry, it's the purpose of this stage.
Okay. Sorry.
I motion to enter into executive session.
Could you read the disclaimer language there in that section, please? For the reason.
Me?
Yeah, Chair, you can state that the board wishes to enter executive session to consult.
Okay. So the board wishes to enter into executive session to consult with the board's attorney on questions and issues pertaining to the board's powers, duties, privileges, immunities, and liabilities in accordance with HRS section 92-5A4.
So we'll need a motion.
Can I get a
Joy
motion?
Kimura, I'll make a motion to enter executive session.
This is Corinne DeSoto, I second.
Thank you. That's all we need, right? Or do we need to know if anybody abstains?
The objections abstentions section part.
Okay. Are there any objections or abstentions? And hearing none, I would like to move to executive session. Do I need to have a roll call to come back?
Yeah, and we'll have to know whether whether everyone's alone or not, again, please.
Can I have a present or a here from members when I call your name and indicate whether you are in the room alone or if anyone else over 18 is present? Vice Chair Dr. Kern DeSoto,
I am present and alone.
Ms. Joy Kimura,
I'm present and alone in my workspace.
and I Chair Dr. Kristen Coles. I'm also present and alone. So we will conclude the discussion of item number 5, testosterone in the naturopathic formulary. We did enter executive session to consult with the board's attorney, and we will be deferring further discussion on this agenda item. We will move on to agenda item number 6, which is our next meeting date, currently scheduled for Friday, December 19th, 2025, 2 p.m. in the King Kalakaua Conference Room. And item number 7 is adjournment. So I guess we do not have to say goodbye to you today, Chris, correct?
Yeah, we'll just keep it indefinite with the board. Yes, happy to be.
Okay, good. Thank you, everyone, for your participation. It's greatly appreciated. And I look forward to seeing everyone around the holiday time. Thank you so much.
Thank you so much. I appreciate everybody's contribution today a lot. And Chris, we're so glad to have you with us still. Thank you so much for all your help and for Jordan as well and everybody there in the room. Thank you.
I echo the same sentiments. Thank you, guys.
Thanks, everyone.